Hi, I'm disability lawyer David Brannon. In this video, I'm going to talk to you about the difference between common law severance and statutory severance that we see in most provinces in Canada. After watching this, you'll have a better idea of how these two are related and how they work with each other and how it may apply in your situation. If you like this video, hit that like button. Don't forget to subscribe and hit the bell notification to get notice of these videos when they come out a few times a week. Now, I've described in other videos this idea of common law severance, and you should go and watch those if you want to have a more in-depth idea of what it is. Common law severance, just as a recap, it is based on this idea of reasonable notice, and the law has developed over time. It is the default in Canada in terms of what should be paid, but it's based on the idea that an employer has to give an employee reasonable notice if they're going to terminate them, and the employer then has the choice to let the employee to continue to work during that notice period, or to just terminate them and to pay them out that money for the period of the notice period. So if the notice period that is by law you're entitled to is a year, the employee can either pay you out a year's pay or allow you to work the next year knowing that your job is going to end at the end of the year. So one of the problems with the common law notice provisions is that they can be contracted out of. So in other words, you could create an employment contract that says no severance pay will be owed and then that's it. The common law was a default, but you could contract out of it. So what happened was you just had employers forcing people to sign these contracts where it was just no severance pay, right? And so that created kind of an unfair situation and got back to the problems where you have people just being fired and it throws everything into disruption because they can't find another job, they can't pay their rent, and they're now going on social assistance. Like, the governments want to avoid that kind of thing. So they stepped in and created, each province has its own employment standards laws that set minimum statutory severance that has to be paid to any employee, regardless of what the contract says. So you're not allowed in Canada to create a contract that doesn't at least allow the minimum statutory severance pay. Now, that sounds great until you look at the details of it, because the minimums are literally the minimums. So it's important to see the differences here because there are big differences in terms of the amounts of pay. For example, if you are someone who has worked 10 years somewhere, 10 years, there's a lot of factors that go into it, but it could be anywhere from 8 months to 15 months of notice that you're entitled to. Therefore, you'd be entitled to 10 to 15 months of pay, possibly, okay? Now, that's under the common law. If your contract takes you outside of the common law and says that you aren't entitled to common law severance, only statutory, the statutory could be limited to like 8 weeks. In Ontario, it can be a maximum of 8 weeks or 2 months. So you're talking 2 months versus up to like 15 months of pay. That's a huge difference. So most people don't appreciate that, but you would be entitled to that bare minimum, but maybe not the whole amount. Now, it's also important, I just want to throw in here, that severance pay in Ontario has a very technical meaning, and I am talking about just severance and termination in general for any province, okay? So if you're going to be doing these things on a province-by-province basis, go get advice from somebody specifically for that province, because in Ontario, severance pay has a very special technical meaning, and I am using that term loosely here in the general sense.